We're very pleased to have Peter Greenbaum today as our speaker. You have his information here. He works with Willents, Goldman, and Spitzer, and he has his phone and email. Peter is the co-chair of the corporate group and a member of the, sorry, I have to move something on my screen, member of the health law group. In connection with his business law practice, Mr. Greenbaum represents businesses of all sizes and structures, including both private and public companies, as well as family-owned businesses in a full range of business matters and transactions. And we'll see that today in his presentation. He focuses on mergers and acquisitions, representing both the buyers and the sellers, in entity formation and structuring, which is important to us as we start our small business, including stockholder agreements, joint ventures, employment agreements, etc. He has extensive experience in a broad range of business sectors, such as preparing and negotiating all associated contracts for the service sector, preparing distribution and manufacturing agreements, and for the manufacturing sector. So he has a lot of experience that'll be very helpful to us today. Before we go on to our presentation, I do want to indicate that we have a couple of upcoming seminars. One is Safeguarding Against Cyber Threats on October 11th. So as a small business owner, you should be aware of the issues associated with cyber and how you can identify the threats and prepare for them. And we also have a presentation, if you haven't seen Bard as a AI platform, this presentation on October 19th will introduce that for you. At this point, we're going to go ahead and turn it over to Peter and talk about the legal aspects of starting a business.
Perfect. And I just need to figure out how to get my screen up. So bear with me. Okay, I think I have it up now.
Yes, it looks good.
Great. All right. So perfect. Welcome, everyone. Thank you for joining us. As Nance said, I focus on corporate law. Corporate law is a very broad-based area, which is basically, I always say to folks, counseling businesses from startup and the whole life cycle of the business. And there's no business that's too small or too big. I have solo startup businesses and then many owner public companies. The goal of this presentation is to give you the basics in terms of startup companies. So the goal is not to go too deep in anything, but rather give a high level of everything. It's nice that we have a small group here. And so I always say, listen, you've got a free attorney right now. Ask as many questions as you want. This is the perfect opportunity. You can put it in the Q&A box. Hopefully I'll see it. If not, somebody, Nance, just wave your arms or something. And I'll certainly leave some time at the end to answer any questions at the end as well. What my goal here is, and again, not to get too deep on anything, but what the goal is to hit the basics of everything. So I'll hit the types of business entities that you can choose from, what the governing documents might look like, and that would be both forming or formation documents and then the governing documents of the business going forward. There's a slew of documents that a new business owner or a startup business owner might sign. I picked the two most common ones that I see on startup businesses, which would be employment agreements and maybe a lease, as those are, like I said, is like very typical for startups. And then lastly, I do get a lot of questions on intellectual property related items for startups. So figured we can touch upon that for a few minutes. The first thing I'll say is from a team perspective, it's always good going into a new business venture to have a team in place. This on the screen is just sort of a snapshot of what sort of team members might be relevant to your business. Obviously an attorney, But beyond, since I'm talking, yeah, it's very important, but beyond that, I would say the critical ones, for example, as an accountant, the first question I ask every client that comes in the door is, who's your accountant? Is your accountant good? Does he or she know your business, your not only business, but your particular business, but your line of business? Some accountants focus on healthcare, some focus on finance. And so if you are in a particular line of business, you want somebody that's possibly even in that line of business. Bankers, you need to have a good banking relationship. Again, very key in terms of cash flow and having, immediate access to the money coming in, the immediate money going out. So you want a banker that's somebody you can trust. Insurance agents, depending on your type of business and business line. You may have various insurances that you need to have in place, and you want an insurance agent that is good with your business. And lastly, a broker. If you're in the real estate business, for example, you want a real estate broker, or whatever type of business, and they could be helpful. So putting your team together at the inception is critical and super helpful, and it will help smooth things out as you go along. You don't want to be scrambling for example, an accountant right before tax season. You want the accountant to be in the loop, in line with your business right out of the gate. So that's the type of folks that you should really be thinking about. So the first part of this discussion is, what type of business entity can you choose from? This is step number one when forming a new entities. Whatever segment or line of business you're in, this is the first step. And whether you're a solo or whether you're with a group of other owners, again, the first step. You can operate your business as what's called a sole proprietorship, a partnership, or a limited partnership. And there, I'm going to kind of talk about them in the same bucket. A corporation, and in the corporate world, there's certain designations that you may hear when tied to a corporation: an S Corp, a C Corp, and a professional corporation. And lastly, a limited liability company. And I'm going to talk about each of those and sort of the attributes of each of those, and the pluses and minuses of each of those in a second. But you should, again, before going into business, right at the outset, you should really think about what entity you want to run your business through. And so first thing I'm going to talk about is what's called a sole proprietorship. This is an individual, so you don't have a partner or partners or co-owners. This is an individual, one person, owning and operating their business. And they do nothing more when forming this business than putting, as they say, a shingle out front, a sign out front. They don't form anything. They don't form a separate entity. Rather, they just open their doors and say, I'm running the business. That is the most simplistic way of doing business. It's also probably the worst way of doing business. So it's simple because you don't do anything in terms of forming it. You just do it. And at the end of the day, or at the end of the year, your profits, your expenses, all of that flows back to your personal tax returns. But as I said, it's the worst way of doing business because critically, you as the individual owner are personally liable for all debts of the business. What are debts of the business? It's everything. This could be lawsuits. This could be accidents and falls in your office. This could be a contract that you signed that there's an alleged breach. It could be any type of operational liability. Maybe you owe a vendor money. You have an employee that you fired that has a wrongful termination claim. Whatever it is, whatever liability we're talking about, you are personally liable for it. And what that means in plain English is, if a third-party creditor were to sue, they would sue you personally. And so all of your personal assets are now exposed. This would be your house, your car, your bank accounts. So while it is the easiest thing to set up, I would tell you it's the worst way of doing the business. And there never would really be a reason for conducting your business in this manner. So with that being said, let's go to the next type of business, a partnership. A partnership is very similar to a sole proprietorship, except it's got more than one owner. two or more owners. And so two or more owners can go into business. From a formation perspective, it is very simple to start. What happens? You talk to your co-owner, your co-partner or partners, and you say, let's go into business together. You do nothing more than that. Again, from a starting point, very simple. You don't do anything more than talk to your partner. But similar to a sole proprietorship, it offers no protection against personal liability. So all those examples I gave a minute ago are relevant for a partnership. If you are running a business through a partnership, all those creditors could sue now both of the partners or all of the partners, however many you have. So again, that's a big negative. The positive is it's very simple. You don't do anything to form it other than talk to one another at the end of the day, or again, at the end of the year. From a tax perspective, everything flows back to each partner's tax returns. So profits, income, losses, expenses, all that flows back to the individual tax returns. But again, in this world today, there's really no reason to be doing business through a partnership, but it is in fact a type of business venture. So I wanted to mention it. The next is what's called a limited partnership. A limited partnership is slightly more advanced than a regular partnership. Number one, you actually do file something with the state. It's called a certificate of limited partnership that shows you have a partnership. And in that construct, you identify both what's called general partners and limited partners. And it's the same starting point as a regular partnership. But the key here is that the limited partners that are identified have liability protection. The general partners do not have liability protection. So if you are a general partner of a general partnership, you have the same personal exposure that we just described in a sole proprietorship and in a regular partnership. And I cited the partnership law here. A general partner of a limited partnership has all the liabilities of a partner in a partnership. On the flip side, though, the limited partners, they do in fact have a shield over their exposure. And as a limited partner, they don't have that same risk that the general partner or that sole proprietorship would have. The downside from a limited partner's perspective is that for that shield of liability, that those individual limited partners cannot have any management rights, no vote by any means. So you have basically silent limited partners. And so again, I cited here the partnership law. A limited partner is not liable for the obligations of a limited partnership unless he's also a general partner or he takes part in the exercise of rights and powers as a limited partner. He takes control of the business. Then that would make that person, that partner, a general partner, and then he or she would have exposure. That type of structure is used a lot for real estate investments and estate planning, but I'm going to put that in the same category as the other two categories that I just mentioned, sole proprietorship and partnership. There's really no reason for most businesses to be operating in this fashion. So I give you all the downsides and all the things you shouldn't do. So let me tell you what you should do. The two buckets of entities that you should think about, one is what's called a partnership. I'm sorry, one is what's called a corporation, and one is what's called a limited liability company. Both of them now shield the individual or individuals from liabilities. If there are 2 owners, 10 owners, 100 owners of a corporation, those owners in a corporation are shielded from personal liability exposure for the most part. So back to all those examples I gave earlier, a vendor that is suing, a breach of contract and a third party is suing, somebody fell in the office and broke their arm and is suing. Well, who do they sue in that scenario? They sue the corporation, not the 2, the 10, the 100 owners. You've shielded yourself from personal exposure. And that is great. And I would almost look at it and say it's like an insurance policy. It's basically a one-time payment up front that you form the corporation, and now you've provided personal liability protection to all the owners. There are, as I mentioned earlier, there's what's called CNS corporations. CNS corporations are tax distinctions, which I'll talk about in a second. But at the end of the day, there's the only scenario where an individual owner, again, using my example, 2 or 10 or 100 owners, the only scenario where they would be held liable for the entity's liabilities is when there's a scenario of what we call piercing the corporate veil. Piercing the corporate veil means it's really a sham entity, a sham structure, and the entity itself is doing nothing more than trying to act as a shield, but not actually doing any business. And so giving common examples, and there's a bunch of bullets on the screen right now of common examples of what a piercing the corporate veil scenario would be, but it's basically if the company is underfunded, the company, or there's various companies that are sharing space and equipment and employees and resources, and they're moving money from company A to company B and sort of blending everything together. When you're not treating the entity as a standalone business, then others do not necessarily need to treat it as a standalone business. And that's where you're going to risk bringing down that corporate veil, so to speak. And it's a lot more, it's not as scary as it sounds. It's a lot more simplistic than it really is made out to be. Basically, you just need a separate bank account for the business. You need to have payroll for the business, assuming there's employees, and running the business as if it's a real business. So when you have a contract with a third party, you sign the contract not individually, but in the business's name, and things like that is really acting as if you're a standalone business. I mentioned earlier C Corps and S Corps. These are purely tax designations. And what I mean by that is that I've spent a lot of time talking about shielding an individual from personal liability. Whether you are a C Corp or an S Corp, you still have that same you still have that same liability protection. The distinction is it's a tax distinction. And so when I spoke at the very beginning of this conversation of pulling in that team, one of the folks I said is your accountant, and this is the perfect example of pulling in your accountant. When you form the entity, you would designate how you want to be taxed as a C Corp and as an S Corp. And there's reasons why you may be one over the other. And it's all from a tax perspective. But generally speaking, what we say is C Corps are what we call double taxed, double taxation. Money comes into the corporation, it's taxed. Money comes out to the individual owners, it's taxed again. So using very simple round math, $1,000 is earned by the corporation. $1,000 comes in the door. The corporation pays tax on it, let's say at a 30% rate. So $1,000 now becomes $700. And then that $700 comes out to the owners and it's taxed again. Again, let's make it up at a 30% rate. So now that $700 is taxed again at 30%. And that leaves you with give or take $500. So you started off with $1,000 and you end up with $500 in your pocket. An S Corp, on the other hand, is what we call a single taxation structure. Money is taxed only when it comes out to the individual. So that same example, $1,000 comes in, it's not taxed yet. And then the $1,000 comes out, then it's taxed. Again, using my example, 30% tax rate. So $1,000 is $700 in the person's pocket, or the owner's pocket. So C Corp in my very simplistic example, $500 in a pocket. S Corp, $700 in the owner's pocket. It's very simplistic, but that's kind of the vibe of it. And you might ask, well, why would anyone ever want to be a C Corp over an S Corp? That's a conversation you have with your accountant at the beginning, because there are reasons why you may do one over the other from a tax perspective. And there are limitations in the C Corp scenario of who can be owners. For example, only as a basic rule, only individual humans can be the owner of an S Corp. You can't have a holding company, for example, being an owner of an S Corp. And so some individuals have holding companies that then own various subsidiaries. You can't do that in an S Corp structure. Also, S Corps have other limitations in terms of how many owners they can have. 100 is the going number. Now, you may say that probably doesn't apply to the vast majority of businesses that I'm going to represent. Most businesses I work with are well under 100, but nonetheless, that is a limitation. And you can only have one class of stock in an S Corp. What that means is some corporations on purpose have different classes of stock with different rights. You can't have that in an S Corp. And I will also say the vast majority of businesses I work with only have one class of stock. So it may not be relevant, but long story short, there's tax reasons and structural reasons why you would do one over the other. And you sit with your accountant, you sit with your attorney when you form it, and then you figure out which was best for you. So that's the corporate scenario. And then the last business entity is what we call a limited liability company. This is a hybrid of a partnership and a corporation. You get the upsides of the corporate veil, but also you get the upside of the taxation side of like a partnership, that it's only taxed once. So it's called a limited liability company. And to use my examples, it operates like a corporation in that you have those personal liability protections that a corporation gives, and you have the ability to be taxed once and only once when the money comes out, like that S Corp scenario. So you get the benefit of both worlds. And again, you may ask the question, well, why would anyone ever want to be a corporation when we have the flexibility of a limited liability company that gives you the same benefits? And that is a very good question. And I will tell you that most of the time, the answer will be, let's do a limited liability company, because you get a lot more flexibility and upside, and you don't have the constraints that a C or an S Corp would have. So I will say the vast majority of the time, your accountant and your attorney and you would sit together and probably come to the conclusion that an LLC is the way you would ultimately go. So that's the sort of quick overview of the different types of entities. And just to restate what I've said, there's really no business reason why you would, for the most part, ever run your business as a sole proprietor or a partnership or a limited partnership. The vast majority of the time, you'll be a corporation or a limited liability company. You sit with your accountant and your attorney, you figure out which one is the best for you, and then you go from there. I do want to talk about what's called a professional corporation. Excuse me. In New Jersey, in New York, in many states, if you are a licensed individual, an attorney, a physician, an engineer, an accountant, anybody that's licensed, a lot of times you must form as a professional corporation or a professional association, as opposed to one of the structures that I just said, a corporation or LLC. So without getting into too much detail, just something to think about. If you're starting the business and you're licensed, you may have to be a professional corporation. And then now I want to switch gears to what I would call the governing documents of a business. The first thing, I'll say it over and over and over: tax considerations, liability protection. This typically dictates which of those entities you're going to do or be. You're going to sit with your accountant and your lawyer. You're going to talk through the process, and then you're going to form the entity. Now, formation. What do we do to form an entity? If you are a sole proprietorship or a general partnership, you don't need to do any filings out of the gate to form them. You just operate the business, and de facto, you are a sole proprietorship or partnership. The other entities, a limited partnership, a corporation, a limited liability company, there is certain filings that you need to make with the state, relatively easy, relatively quick. And so to dig down a little bit more, and since I focus on the corporation and the LLC, I'm going to focus on what needs to be done for a corporation and an LLC to form. It's a very short, simple process. Typically can be done within, I'll say 24, 48 hours, and it can be done with your, accountant or attorney's help online, and, through fax filings and online filings. But you need the name of the entity, needless to say. You need to have the proper ending of the entity. So if you're an LLC, it would end in LLC or limited liability company. If you're a corporation, it would end in Inc. or Corp, or a variation of along those lines. If there is an entity name already in existence when you form that with the same name, you're not going to be able to use that name. So you're going to have to find a different name. The formation documents, you have to put what the purpose of the entity is, and you don't need to be specific. You can be, sometimes you do get specific. I'm going to be a real estate holding company. I'm going to be, consulting in whatever segment. But for the most part, you're typically just a very broad stroke. I'm doing anything legal through the entity. From a shares perspective, you need to state how many shares you need or would like to have issued, or the ability to issue, and whether you want classes of ownership. And as I said earlier, for the most part, most businesses don't get into different classes unless it gets a little bit complex with different rights and among owners. So usually these are very simplistic statements. It's an arbitrary number: 100 shares, 1,000 shares, one class of shares. And then lastly, you need to designate what's called a registered agent, and that's nothing more than a place that the state can send mail. And most states require that you have an address in that state. So for example, if you form an entity in New Jersey, most states, New Jersey would require, or does require, that you have an actual physical address in New Jersey. It could be your home, it could be your business, it doesn't matter, just as an address. If you don't have a physical office in New Jersey, sometimes attorneys or accountants will act as such. And then there's third-party expediter companies that will act as such. But at the end of the day, there's no purpose to the registered agent beyond having a place that the state sends mail. Once you file, and here's the offices that you would file, depending on what state you're in: Secretary of State or Department of Treasury. Some states have something more specific. So for example, if in New York, if you're a licensed individual forming an entity, they want you to get the Department of Education approval first. If you're in a quasi bank, an insurance company, or something along those lines, you might need the Department of Banking and Insurance approval. But for the most part, for the vast majority of businesses, you file straight through and straight to the Department of Treasury or the Secretary of State. And as I said, 24 hours, give or take, you're formed. And then once you are formed, the immediate steps after that, you get a taxpayer ID number. That's like a social security number of an entity. You or your accountant can do that online pretty quickly. Once you have the taxpayer ID number, you go and open a bank account. You obtain any types of insurance you need. If you're making that S election, which I discussed before for an S Corp, you make it at that time, and then you're ready and you go. And that's it. It's as simple as that. And that process I've just described, the paperwork, the back and forth, 24, 48 hours. Then the next topic would be, what governing documents do you want for the entity? If you are a single, and again, I'm going to have the conversation assuming you are either a corporation or an LLC. So if you are a corporation or an LLC, you will have possibly what's called a stockholder agreement, operating agreement, or partnership agreement. Those phrases and terms are used interchangeably. But basically, that's the document that governs the ownership structure going forward. If you are the sole owner of the corporation or the LLC, you don't necessarily need one of these documents. If there is more and probably you don't need this document. If there is more than one owner of your business, then you definitely want to have the conversation of these documents. And what are these documents? There's nothing from a legal perspective required in most states to have one. I'm going to call it a stockholder agreement. There's nothing legally required in most states to have a stockholder agreement, but from a business perspective, it is super important to have a stockholder agreement in place, ideally when you start the relationship. And why? This outlines your understanding of the deal and your business relationship going forward with your owner or owners of the business. Again, 2, 10, 100, whatever it is, it outlines the understanding of the ownership. If there is no stockholder agreement in place, you haven't violated the law or anything, there is a statute in every state that governs corporations and LLCs. And in the absence of a formal written agreement, that statute would control. However, you do not want the statute to control if you can help it. And why is that? Because the statute may not necessarily get you to the result that you want. And so what I would typically tell clients, this is an agreement you put in place, again, ideally at the early stages of the business. You put it in a drawer, you never look at it again. And the only time you'll look at it is when there's a problem. If everything is going great, it's never going to be looked at. But if there's a problem, you want to be able to take it out and at least have that document, hopefully, answer the question or address the issue that's in front of you. I've got many clients that don't have these types of documents. Sometimes it works out fine. Sometimes it doesn't work out fine. I've had clients who have documents in place that don't reflect what they actually want. Sometimes they go and they, find something online and they say, oh, here's one online. I'm just going to pull it. Let's sign it. Well, that's even worse than not having a document, because that document is going to control. And if it says nothing what you want it to say, then you're bound by it, even though it doesn't make any sense. So you want to think through the stockholder agreement carefully and work through it. And so let's talk about more specifics. What would be or could be in this document? First is, who are the owners and what do they own in terms of percentages? You would say, hey, this is a silly question. Of course, we know who the owners are. And of course, we know what the percentages are. I will tell you, I've had deals and issues, clients come in when they did not know or could not point to a document to say who the owners are and what the percentages are. And needless to say, they're coming in my office because they're sitting there saying, I think ownership is 50-50. And yet my co-owner thinks they own 75 and I own 25%. You say it should be easy. You say it should be, common sense. Believe me, I've had many situations where it's not. So the first thing is, who are the owners? What do they own in terms of percentages? The second is, how are decisions made? In a corporation, in an LLC, just because you are an owner does not necessarily mean you have a vote. You could always say, and I always use the example, you could have somebody own 99% of a business, somebody own 1% of the business, and yet the 99% owner has zero input in terms of decision making and basically is a silent partner. And the 1%er makes all the votes, makes all the decisions, and does everything in terms of decision making. And that could be what the deal is. So long story short, on the decision making, a governance document would spell out what type of vote is required, who has the ability to vote, and are votes made on a majority, some sort of supermajority, unanimous, and just sort of walking through the different decision-making trees and how you want a vote to be theoretically worked out to impact the decision. If we do not address this in a document, majority rules. Corporate law dictates majority rules. And as I said a moment ago, you could be 99-1 and 99 have no vote. So you have control over it at the early stages to put into your documents how you want the voting to happen. I also have entities that put in a deadlock provision. What if the owners can't agree on a decision? What happens? What's the fallback? What's the dispute mechanism? You certainly don't need that, but you can certainly consider it. The next concept is what, and this might be one of the more important topics on all of this, is what is the expectation in terms of money, in terms of duties and time commitment. Just because you are an owner does not mean you are required to do any work. And just because you are an owner does not give you the right to do any work. And what I mean by that is I once had a husband and wife come in. They owned a restaurant with another husband and wife, and they were 50-50 partners. One husband and wife, the one that came to me, said, I come in every day, I work 80 hours a week, I'm doing all of the work. My 50% husband and wife come in on Friday nights, they sit at the bar, they walk around the bar at the end of the night, they take half of the cash out, put it in their pocket, and leave. That's all they do. And needless to say, the husband and wife that came to me said, I'm very upset. What can I do about this? Because I'm doing everything and they're doing nothing, but yet they're getting half the money. And I said, first thing, what does your stockholder agreement say? And you know where this is going. They didn't have a stockholder agreement. Point being is that if it's not in a document, nobody is obligated to ever show up. Nobody is obligated ever to do any work. So you address that up front before there's that type of problem. And then last on sort of the governing document, sometimes I say the governing document can be looked at as like a prenup agreement when you're getting married, which is what happens at the back end of the relationship when you want to separate. Somebody passes away, somebody retires, somebody can no longer work, somebody doesn't want to work. What are the mechanisms to get your ownership either bought out or not bought out? What's the terms? And a starting point I always tell clients is ownership is like a car, it's like a pencil. You own it. You cannot, I own a car. You can't come to me and say, I want to buy your car. You have to sell it to me. I can't come to you and say, you must buy my car. No, that's not how it works. We have to have an agreement. That's the same kind of principle on ownership. If somebody wants to retire, that retired person does not have the legal right to go to the other owners and say, you must buy me out. And if somebody stops working, somebody does something wrong, the other partners can't go to that individual and say, I want to buy you out and you have to sell to me. It doesn't work like that. The stockholder agreement would provide for all the mechanics. What happens if somebody passes away? Does the ownership go to the spouse, to the children, to the beneficiaries of the estate? Or does the other owners have the right to buy out? Or can the estate hold on to it? What's the mechanics? And if there is a buyout scenario, how is it valued? You don't want to then just sort of have an open-ended, you want to have a process. If there is a buyout, which we would agree to in the governing documents, what's the mechanics of valuing that? Again, you don't want to leave it to the last moment to figure it out. It could be a formula, it could be a fixed amount. You can say a third-party accountant or third-party appraiser, they would value it, whatever it is, you would address it at that time. And then last but not least is what we call a restrictive covenant, which is if somebody's going to be bought out in this whole construct and be paid money, you don't necessarily want that individual then to open up a new business right next door, doing the same thing, calling on the same clients while receiving a buyout. This is a restriction to say, well, our deal is you're going to be bought out, but perhaps you have some type of restrictions on what you can do after the fact so that those who are buying the ownership get the value of the ownership. So that's the long, high 10,000 foot high level concept of what we would typically see and discuss in a stockholder agreement, operating agreement, or partnership agreement. Again, we use the concept of the terms interchangeably, but again, it's the relationship of the owners going forward. And before I move to the next topic, I just want to stress that these documents are not legally required. You haven't done anything. If you don't have one, you haven't done anything wrong. There is a body of law to fall back on, but you never, ever, ever want to be in that position. Unless you want to be in that position, you never want to find yourself in that position, because usually the only time you're taking these documents out is when there's a problem. And when there's a problem, people behave differently. They have different agendas. And you want it to be going as smooth as possible rather than as bumpy as possible. The other types of agreements that I typically see that I do want to quickly touch upon in startup businesses are what's called employment agreements, kind of just what it sounds like, and office leases, again, kind of what it sounds like. So quickly on each one, an employment agreement. First, I want to talk at a high level of an employee versus an independent contractor. In New Jersey and most states, the basic is an employee is somebody who gets a paycheck. They have withholding taxes taken out of it. They're characterized as an employee, and as such, there's a body of law that under both federal and state law that deals with employee and employee rights. Conversely, there's something called independent contractors. There's typically no withholdings taken off of that. They're independent contractors. They're more of a flexible, I can do what I want while I'm not with you concept. There's reasons why individual and businesses may want one as opposed to the other. So when the time comes and you're thinking about having somebody that is going to work for you, whether full-time or part-time, you have the conversation with both your accountant and your attorney in terms of how do we want to designate the individual. Are they an employee or an independent contractor? If you want, you can have an agreement with both of those folks, an employment agreement or a consulting agreement. I'm going to talk momentarily or a little bit about employees in New Jersey. Everybody is what's called an at-will employee in New Jersey. So unless you have a written employment agreement that would say otherwise, in New Jersey, as an employee at will, you can be fired and you can quit for any reason whatsoever other than being fired for a discriminatory reason, race, religion, etc. Other than that, you can be fired with or without cause, with or without notice. Don't necessarily need to pay severance. Again, the caveats on all of that is if you have some sort of agreement in place, an employment agreement, a handbook or whatever, that would ultimately control. Otherwise, everybody in New Jersey defaults back, everybody being an employee, defaults back to employees at will. If you were to have a formal written employment agreement, you could touch upon topics such as what is the start date? What are the duties that the individual employee is supposed to do, full, part-time? What are the specific titles and responsibilities? What their compensation is? Are they a flat salary? Is there a bonus? What have you? What are the benefit rights, health insurance, etc.? What's the vacation policy? Is there some type of partnership or ownership opportunity going forward? And what are the termination rights? And as I said a moment ago, unless we say otherwise, everybody is terminable at will in New Jersey. So sometimes you have specific termination rights. And then lastly is a restrictive covenant. And I touched upon this a second ago briefly. A restrictive covenant is a provision that prevents an individual from doing certain things. The typical ones are it would prohibit an individual from soliciting clients and employees and referral sources of the business. So meaning employee X, you can't solicit clients for some period of time after you leave. And even more so, there's what's called a non-compete, which is you can't be in a competing business in a certain geographic area, 10 miles of the office, the state of New Jersey, whatever, for a certain period of time. Those are very, needless to say, restrictive, hence the name restrictive covenant. There is legislation in New Jersey, there's legislation in New York that is trying to severely cut back on what an employer can have in terms of restrictive covenant, to the point of trying to make them not applicable, not valid. But nonetheless, as we sit here right now in New Jersey, you can have restrictive covenants in New Jersey on your employees as long as they're reasonable. Some states have already outlawed them. For example, California, they don't allow them anymore. So it's very state specific. So that's the high level concept of an employment agreement. And again, just to sort of give a closing remark on an employment agreement, you don't need to have an employment agreement with an employee. The most relevant reasons to have an employment agreement with an employee is if you want a type of restrictive covenant, if you want, or if there is some type of maybe more complex compensation structure beyond just an X dollars per year or X dollars per hour. If it's something more complex in terms of compensation structure, those are the scenarios where you typically would want a formal employment agreement. Otherwise, it's a very touchy-feely, do you think it's appropriate or not concept. Switching gears very quickly to leases, just in terms of the general things that are typically come up on leases, and I do want to just hit this very quickly due to timing, but the basic topics that pop up in leases that you want to think about is, what is the rent? In terms of the monthly rent, what is the rent in terms of what we call common area maintenance charges? If you are one office in a 10-story building, you may have monthly rent of $1,000 per month. And on top of that, you may be required to share in your percentage of what we call common area charges, the electricity for the common areas, the janitorial services for the bathrooms and the main lobby, the landscaping and the snow removal for the parking lot, that type of thing. So number one is understanding from an economic perspective what the rent, the full package of rent is. Number two is who's responsible for utilities, gas, heat, electric, water, etc. Is that a landlord responsibility or a tenant responsibility? Number three is how long is the lease in terms of years, and do you have the ability to renew the lease as a tenant? And what that means is you may have a 5-year lease, and a lot of leases provide, for example, that the tenant has the right to stay another 5 years, renew the lease at its option, period. Landlord can't say no. If the tenant wants to stay, the tenant can say stay at some predetermined rental amount. And then lastly, the big thing is who is responsible for maintaining and repairing the space? What if your air conditioner in the space breaks? What's the typical, cleaning responsibilities for your space on a nightly basis? Things like that. Is that a landlord responsibility, a tenant responsibility? And a lease relationship would spell all of that out. Some leases can be 2-3 pages long, and unfortunately some leases can be, I've seen upwards of 50-60 pages. There's no right or wrong answer, and so you just really need to know what you're signing before you get into things. And then lastly, very quickly, is what I call intellectual property considerations. Some folks form a company, they may have a logo, they may have a trade name that they use, they may have a tagline that they use. If that name, logo, tagline, if that is important to your business, you're going to put it on products, on the sticker, on the label outside of your product that you manufacture, or the product that you roll out, or your software that you're developing. It's going to be the marketing name of that, the brand name of that software. If you have a logo, a name, a tagline that is super, super important to you, that is core to the business, you should really think about what we call a trademark filing. By forming an entity, using that or forming that entity and using that trade name in business gives certain rights, by rolling out a new product with a name, brand name on it, gives certain rights in that usage. But if there's other businesses that are already using that product name, that business name, they have superior rights to you. They can tell you to stop using it. You don't want to spin out a new product line, invest a lot of money in a new product line or in a business name or whatever, only to find out 6 months, 12 months after you started rolling it out, you get this ugly, what's called cease and desist letter. It's a letter that says, you're using a particular name, you can't use that name, you got to cease and desist, stop using it immediately. You don't want to get that letter after spending a lot of money ramping up a product or a business name. You want to know out of the gate whether you've got the right to use those names and then protect that name. So from an intellectual property perspective, you really want to think about it if there's a name that's core to your business of looking into trademark filing and protection. So I know I ran through this pretty quickly. I have 5 minutes left, so I just want to open it up to questions and answers if anybody has questions and answers.
We have no questions at this point in the chat. I do have one now in the Q&A. Re-employment agreements, would you recommend a confidentiality agreement?
So good question. The answer is it depends. If you have something that you want to really keep confidential, pricing of your product, financials of your product, contact information of your vendors, of your clients, whatever, then definitely I would consider having a confidentiality agreement with your employees. There is a pretty basic set of documents that is short of a big, long, ugly employment agreement, but it protects you, and a confidentiality agreement falls in that bucket. You can have a pretty solid confidentiality agreement with your employees that's very short, a paragraph or two long. That's part of like your handbook or part of just sort of the introductory onboarding paperwork of new employees. And so the short answer is good idea to have that if you have something that you really feel is worth protecting.
Great. And Dante has a hand raised. So I'm going to open up your line if you want to go ahead and ask your question, Dante.
Can you hear me?
Hey, Dante. Yep, we hear you.
Okay, yes. My question is, I am thinking about restaurants and as a chef, and the questions about food safety. I know I got like tons of overview, and that wouldn't be a concern. But is there anything I should know there?
So you say restaurant, I think liquor and liquor license related stuff. And I think, food illness issues. So without harping on forming an entity out of the gate, which is 100% what you should do, you should also talk to your insurance agent, because you definitely want liability insurance on the business, on the restaurant, that is good enough coverage for risk exposures, Dante, to both like liquor related issues and food related issues. I mean, that's the starting point that jumps to mind. In terms of protecting yourself as an owner.
Thank you.
Yeah, hopefully I answered the question.
Yes, thank you.
Anybody else have any questions? Oh, Peter, we really appreciate your, oh, now I have another hand raised. Let me, S. Melvin, you want to ask your question?
Yes, thank you. And thank you for answering my other question. One of the things, whether you go in, if you go into a partnership with one or several other people, would it be advantageous to like do a background check on each other, just to make sure there isn't anything in the background as far as.
Well, I think the short answer is, short answer is, there's definitely no downside to that. You need approval to do background checks. I believe you need to get the person's approval, but
Yes.
in my mind, there's no downside to that. And I will even go a step further, since Dante just, was talking about a restaurant industry. If you have, if you're in a business segment that has a license, for example, again, I'm thinking liquor licenses require background checks be done by the ABC,
Yes,
the bureau who governs liquor licenses, and to make sure from a background perspective, the owners of the liquor license are in good standing. So if there's a license component, great idea, and quite frankly might even be a requirement. And just in general, then there's no downside to it. Now, I will say honestly, in the non-licensed world, I rarely have that done. Most of the time, there's a certain comfort level with the co-owners coming in. They already know each other. They have a comfort level. So I will say in my experience, it's rarely done, but there's no downside to it from my perspective.
great, thank you.
Thank you. Any other questions? All right, Peter, we really appreciate it. You covered a lot of very valuable material in that hour, and we couldn't have asked for any better.
Great. And Nance, I don't know if everyone has actually they do. They have my email address. So if anyone has questions, drop an email. I'm good with emails. I'd be happy to talk if you want. I'm open to answering any questions.
Sounds good. I will be sending out the screens, the slides, which does have the information. So
Perfect.
thank you very much. And this will be recorded. It is recorded and will be put on our website as well for future reference.
Perfect.
Thank you
Appreciate
all
it,
very
everyone.
much. All right, take care.